Meaghen Russell, and we're back today as part of the Global Labor and Employment series called World at Work. Last time we heard from our Toronto, Canada colleague, Claire Brown, who spoke to us about the top 5 noteworthy cases and issues that we're seeing in Canada regarding employment law in 2023. Today, I'm joined by our Dentons Indianapolis colleague, Kate Erdel, who's going to talk to us about the 5 noteworthy issues in the US at the moment in 2023 regarding employment and labor law. Hi, Kate. Great to see you. Thanks so much for joining us today.
Hi, Megan. Thank you. Happy to be here.
Great. So, Kate, let's just get right into it. If you want to start walking us through the top 5 highlights or noteworthy issues that employers do need to know about in the US coming out of 2023.
Sure. Well, things are always changing, but one of the things that has been coming up very frequently in my calls and conversations with clients is related to a federal issue covering all states and all employers and employees in the United States related to confidentiality and non-disparagement. So the National Labor Relations Board, which is the board that oversees the National Labor Relations Act that applies to non-supervisory employees, ruled in February of 2023 in a decision called McLaren-McComb that employers can no longer use the same kinds of broad confidentiality provisions and non-disparagement provisions that they typically have used in their severance agreements with employees. And so what this means is that currently we are unable to use the same types of restrictions that we could to prevent employees from discussing the terms of severance agreements that they receive from their employers. It also means that employers need to be careful about what kinds of agreements they put in place regarding non-disparagement. The reason for this is that the National Labor Relations Board wants to be sure that employees' rights with respect to terms and conditions of their employment aren't being restricted by the agreements that their employers ask them to sign upon termination. Employers have been responding to this in a couple of ways. One is to just remove those provisions entirely from their agreements. The other way is to modify those provisions so that they are not as broad or so that they have very specific carve-outs, or to just include a provision that says something like nothing in this agreement does or is intended to violate the employee's rights under the National Labor Relations Act.
And Kate, in terms of the non-disparagement, would that be permissible if it was a mutual non-disparagement clause, or is there just sort of a complete prohibition against non-disparagement clauses for non-supervisory employees?
The McLaren-McComb decision doesn't discuss whether or not a mutuality provision might save these types of provisions. So in one argument, you might say, yes, it could. And in another, you might say, no, it can't. So we don't really know yet exactly what the parameters are. There have not been any decisions ruled upon that I'm aware of anyways, where the National Labor Relations Board has further discussed the parameters or the boundaries of when and whether such provisions might be enforceable or might be overbroad.
Right. Okay, if you can take us to the second highlight.
Sure. So the second issue is another federal issue related to non-competes. So traditionally, many employers in the U.S. have used non-competition provisions in their employment agreements that restrict employees' abilities to find new employment or work in certain areas or certain types of jobs once they've left their current employer. And those provisions are typically upheld and have typically been enforceable under the law in most states. Some states have outright bans on non-compete provisions, but most states do allow them as long as they're reasonable and narrowly tailored to try to achieve an employer's interest in protecting its confidential information and trade secrets and its customers and its clients and its employees. However, the Federal Trade Commission has been discussing whether or not non-competes impede trade. And if they do, and if they unfairly impede trade, then should such provisions be permitted? Earlier this year, the Federal Trade Commission requested input on a proposed rule that would ban non-competes in most employment-related circumstances. Employers had the opportunity, employers and all people had the opportunity to provide input on what that rule might mean and what it might look like. And that information was due back to the Federal Trade Commission in April. It is not expected that any sort of ruling will come out from the Federal Trade Commission until sometime in 2024. But at that time, it is possible that this new rule could take effect. And if the rule that has been proposed took effect, it would mean that non-competes in employment agreements are most likely and in most circumstances going to be eliminated or not permitted. It would also mean, under the Federal Trade Commission's proposed rule, that non-competes that currently exist in an employment agreement for any given individual would need to be rescinded in writing to the employee.
Okay, and with respect to this potential ban on non-competes, do we know, would this just be specific to non-competes in employment agreements, or would they apply to non-competes that may be found in other type of documentation, such as restrictive covenants or incentive compensation type agreements?
That's a good question. It would apply across the board, whether or not it's in an official employment agreement or in an offer letter, or even in some sort of handbook or something like that. Anything that would bind the employee and keep the employee from being able to obtain new employment post-termination would be considered a non-compete and would be banned. One exception that's notable, though, and that's important to point out, is that this rule would not impact the ability of a company to have a non-compete in place in the event of a sale or a transaction. So if there was a transaction between a business where a business is bought or sold, it would still be possible in the context of those documents, an asset purchase agreement, for example, or an operating agreement, to have limitations on what a seller or an owner or a founder could do post-termination. So that would be one carve out that has been suggested. And it appears that there will likely be other carve outs as well, perhaps for employees who make a certain amount of money. There might be a financial limitation that would be in place, such that people who make over a certain amount of income in a year could still be bound by a non-compete in certain circumstances.
Right. All right, we can move on to our third highlight, please.
Okay, sure. So the third one is another federal issue, and this just hit the books on June 27th, 2023. So we have no case law yet, no decisions about what this act means, but the act is called the Pregnant Workers Fairness Act. And what this new act does is specifically codifies protection for pregnant workers. Under the US law currently, or I guess pre-June 27th, 2023, what we've had for many years is the Americans with Disabilities Act, which is a set of laws that prohibits an employer from discriminating against individuals with a disability. The ADA also requires employers to make reasonable accommodations for individuals who are disabled. There's one provision of the ADA, though, that's always been interesting and maybe confused employers and employees alike, that talks about when and whether or not pregnancy in and of itself is a disability. So what the Pregnant Workers Fairness Act has done is specifically codified the law to say that employers are also required to accommodate workers who need an accommodation due to pregnancy, childbirth, or related conditions. This goes hand in hand with another statute that's been on the books for a long time that specifically prohibits employers from discriminating against workers because they are pregnant.
Okay, so practically speaking, if the duty to accommodate was already in place, what might this look like in practice? And do you think employers need to amend any pregnancy-related policies to reflect this new act or this legislation?
So practically, I'm honestly not exactly sure how it's going to impact employers or employees, because arguably an employee who needed an accommodation previously due to a pregnancy-related condition likely could have been determined to have been disabled at that time under the ADA already, such that an accommodation would have been required, regardless of whether the reason was pregnancy or something else pregnancy related. That said, it does give, I think, employers pause to make sure that they are considering whether or not a pregnant worker is presenting with something that might need an accommodation. One of the important things to know about accommodations under both the ADA and the Pregnant Workers Fairness Act is that an employee doesn't have to make any sort of specific magical request. There are no specific words that have to be used in order to indicate to an employer that an accommodation might be needed. When an employer has reason to believe that an accommodation might be necessary due to a disability or now pregnancy, it's the employer's burden to move forward with talking with the employee about whether there's anything that the employer can do to ensure that the employee can perform the essential functions of his or her job. In terms of whether or not policies need to be updated, absolutely. I would recommend that all employers who qualify under Title VII, meaning they have 15 or more employees, would make sure that they update their policies to specifically indicate that they will provide accommodations to workers who need them due to a pregnancy-related condition.
Okay, great. So moving on, focusing on the states. So we can talk about our fourth highlight, please.
Yeah, sure. So highlights 4 and 5 are both what I consider to be state trends. So these do not apply in all states. They do not affect all workers, but there are a couple areas where we've seen a lot of growth over the last few years in terms of how states are responding to certain employee and employer related issues and laws that are changing in individual states, and also sometimes in specific locations like cities or counties. So one of those is pay transparency. One of those is pay transparency. And a growing number of states, 8 so far, which doesn't sound like a lot, but it covers at least 25% of employees in the US, is a pay transparency component of the law, which basically just requires that employers in their job postings or in their job advertisements when they're recruiting, that they indicate to the applicants what the range of the compensation is for that particular job. So previously this has not been required, and employers had no obligation to let applicants know what the pay might be for any given job. But now that information is required in the states that have adopted these pay transparency laws.
Okay, thank you. And would you say, do you expect that over time most states are likely to adopt this pay transparency legislation, or is that too much of an unknown at this point?
If I could predict that kind of information, I would be doing some other job, right? I think, no, I think that the answer is, when we say most, I would say I don't expect it to be most, at least not in any sort of short term. Instead, what we typically see is that states who are active in state-based legislation related to employment adopt all of the things. And then those states that are less active will adopt none of them. So I think we can usually assume that there's about a third. I think we'll get to a third of states will adopt, or at least start considering pay transparency provisions over the next several years. Okay,
great. And over to you in terms of our final state-specific highlight for today.
Yeah, so the final one is one that really kind of the scale started to tip during the COVID years, if we want to call them that. And prior to the pandemic, what we saw was that most family and medical leave was governed by federal law, the FMLA, which does not require any sort of pay. So under federal law, certain employers with a certain number of employees are required to provide job protected FMLA leave to employees. However, that leave can be unpaid, meaning that employees who go out on FMLA leave may be spending that time not getting paid by their employer. The new law that has come into effect, or the new trend that we started seeing in a variety of states, California, Maine, for example, include requirements that employers provide employees with a certain amount or a certain number of days of paid sick leave, or in some states, paid family leave as well. And so it mirrors the FMLA in many regards, except that there is a pay component. And this is something that we have seen changing. And like with the pay transparency laws, I would expect that we will get to a large number of states that have this type of requirement. And then whether or not the federal side picks it up and wants to turn it into a federal requirement, that will be really what we want to keep our eye on. Right now, I would say that we have so there are currently 15 states and a whole mass of smaller jurisdictions, states and counties that have some sort of paid family or sick leave requirement on the books. And it makes it really complicated for multi-jurisdiction employers, because they have to then be mindful of not only where do their people live and reside and work, but also what specific laws apply in those specific places. So that is made for a complicated, puzzle for many employers trying to make sure that their policies and procedures comply with the law. So I think that's something that we'll need to continue to watch for, to see whether or not the federal government picks up on this issue and makes any changes from a federal standpoint.
Great. And would you suggest that employers return to their sick leave policies or their PTO policies to amend them to reflect the fact that these paid sick time or paid family leave is now available to employees?
Yeah, in the states where it is mandated, yes, absolutely. I think all employers should confirm that they are current with the requirements in the state where they have employees, both in terms of where their employees live, how many employees they have, to ensure whether or not they are actually covered and are required to comply. So yes, absolutely. People should be mindful about where they are working, where their employees are working, especially with respect to remote workers. Remote workers are typically treated under the law of the state in which they primarily live and work. So even if an employer says, well, we're based in Indiana, but we have several employees who live in California, they will want to be mindful and make sure that they are applying the correct California law to the employees who live and work in California.
Okay, great. So it sounds like even if it's not a legal requirement to have the policy change captured in writing, it's certainly a best practice so that there's clarity with respect to what new laws or what entitlements apply to which employees.
Yes, absolutely. I think both to make sure that employees are aware of what their rights and benefits are under the law and under their employer's policy, and then also to make sure that the employer itself is complying. There's also usually a need to make sure that the payroll company, to the extent that that payroll is outsourced, make sure that the payroll company is treating people properly and documenting the way that leave is being used and paid. One of the things that a lot of clients of ours are doing is doing more of a nationwide survey to see where they have employees, what are the policies and procedures that they currently have in place, and is there a way to create a policy, create leave pay provisions that would cover the rules that are required in any given state. Because it's difficult, obviously, for an employer to manage employees in every single state if the rules in every single state are different. And many employers do that, but it becomes a bit of a nightmare when the law keeps changing. So one of the things that a lot of employers have been doing is trying to say, okay, what's the most generous policy out there? And then how can we apply that to all of our employees?
Right, makes sense. So one last question for you, Kate, as we wrap this up. For employer clients, for employers generally, are there any resources available in terms of employment, labor law updates that we can point folks to in the US?
Well, sure, there's a lot, almost too many to even just name. So I always direct people to the employment page of the Dentons US website, which you can find by just typing in Dentons employment law, and it will pull you right up to our page. We post a lot of blog posts and updates, and also have trainings and things of that nature. I don't have any off the top of my head that I want to point to right now, but we are constantly putting out content and pointing clients in the right direction.
Well, I've seen it and it's quite robust. So if there's any questions that follow from this, there's a likely chance that there's going to be some answers found within the Dentons US employment page. So thanks so much, Kate, for your time. This has been terrific. A lot of helpful, useful information for clients that they certainly need to know on a go forward in 2023. So thank you again for your time. And to our viewers more generally, please stay tuned. There will be more in this series, this World at Work series, from other Dentons colleagues across the globe. So we look forward to seeing you again. Thank you.